Hi, everyone. We're just waiting a moment to hear from IT and all that to make sure that they're ready to go. Oh, and we got the thumbs up. We are ready to go. Okay, so good morning, everyone. Welcome to Assembly Judiciary. Just a few housekeeping issues before we call roll. Again, just asking that everyone turn down their electronics as to not be a disruption. Reminding folks that we will have public comment at the end. And of course that you can, welcome to everyone here in Carson City. If anyone arrives there in Las Vegas and those watching online, either through Nellis or through our YouTube channel for the Nevada Legislature. With that, I will ask if the Secretary please take roll.
Assembly members Cole, here. Dalia, Gonzalez, here. Gray, Hanson, here. Hardy, here. LaRue Hatch, here. Marzola, present. Moore, here. Nadim, Orentlicker, here. Roth, here. Urick. Here.
And please, yes, Chair Miller is here. And please mark Assembly Member Joe Dalia absent excused. Thank you. And with that, of course, we'll also have public comment at the end of the presentations today. We do have two presentations. Also, for those that are planning to call in to make public comment, I will give the phone number toward the end, but if you want to prepare now, that phone number and the meeting ID is listed on the agenda that you can locate on Nellis. And with that, we will go ahead and begin our first presentation. Our first presentation today is an overview of the Cannabis Compliance Board. We have the Executive Director, James Hum. Is it Hum or Whom? Hum. We also have the Deputy Director, Michael Miles. We have the Division Chief of Inspection and Audit, Kara Cronkite. Cronkite, okay. There's just an extra little letter in there. Okay, Cronkite. We have the Division Chief of Investigations, Dave Staley, and Division Chief of Administration, Steve Gilbert. So are you two here part of the presentation or just to respond to questions or? Okay, wonderful. And so with that, I'll give you a few moments to get settled in, and whenever you're ready, you may proceed.
Thank you, Chair. Members of the committee, I'm James Hum, Executive Director of the Cannabis Compliance Board. Joining me today, the Chair was kind enough to list them out at the podium with me as Deputy Director Michael Miles, as well as our Chief of Health and Safety, Kara Cronkite. Also, Chief Staley and Chief Gilbert are behind us to help answer questions should we have any. Just know whatever measure of success I will have in this appointment will be because of them. They're incredible teams who serve the state with dedication and unrivaled efficiency. Quick background on myself and the agency. Governor Lombardo named me to lead the CCB in December of 2023, whereas in the prior 6 years I had the pleasure of serving the state in various roles at both the Attorney General's Office and Governor's Office of Economic Development. During my 14 months at the agency, we have already, and I know we will continue to accomplish many more great things. Now, if you will, let me please walk you through the presentation. Timeline of the Nevada Cannabis Program. The Cannabis Compliance Board itself was established through Assembly Bill 533, the Cannabis Compliance Board consists of 5 board members appointed by the governor. AB 533 also created the 12-person Cannabis Advisory Commission to study cannabis-related topics and make recommendations to the CCB. In 2000, Nevadans voted to legalize medical use cannabis. In 2015, the first medical marijuana establishment opened. 2016, voters approved ballot question 2, legalizing adult use, also what you probably know as recreational use. 2017, recreational sales began in Nevada. The state's program transitioned from the Division of Public and Behavioral Health to the Department of Taxation. In 2019, Governor Sisolak signed AB 533, creating the Nevada Cannabis Compliance Board, which, as some of you may know, was modeled after the Nevada Gaming Control Board. In 2020, the state's cannabis program transitioned from the Department of Tax to the newly created Cannabis Compliance Board. Our mission statement. Nevada Cannabis Compliance Board governs Nevada's cannabis industry through strict regulation of all areas of its licensing and operation, protecting the public health and safety of our citizens and visitors while holding cannabis licensees to the highest ethical standards. What does the CCB do? What does the board actually do? So the board, as noted, consists of 5 members, all appointed by the governor. The board holds regular monthly public board meetings, hosts ad hoc regulatory workshops, reviews and approves final licensures, transfers of interest, management services agreements, and the like. They also approve the service of disciplinary actions such as complaints, and they act as the final arbiter of discipline and have final approval regarding subsequent settlement agreements. Additionally, they may hold emergency board meetings to consider urgent matters such as summary suspensions. The CAC, as noted before, is tasked with studying issues related to the cannabis industry and making policy and regulatory recommendations to the CCB. The 12-member commission is chaired by myself, the CCB Executive Director. It includes 8 representatives appointed by the governor with expertise related to the cannabis industry. In addition to the Nevada Attorney General, Director of Department of Public Safety, and the Executive Director of the Department of Taxation. Current subcommittees include rescheduling and descheduling at the federal level, market participation, and public safety in the illicit market. The CAC meets at my discretion, similar to the Nevada Gaming Policy Committee. So how is the CCB broken down? We have 3 separate departments. You've met the division chiefs. We have a licensing division, an inspection and audit division, which really oversees health and safety, and an investigations and enforcement division. So let me explain kind of what each of those different divisions do. So the licensing division processes and reviews licenses and renewal applications and also collects the fees associated with those. They manage cannabis agent registration card, or they manage the cannabis agent registration program, registration card program. Currently, we have 20,000 plus active cards, which equates to about 14,500 plus individuals currently working in the industry. They also assist the Department of Taxation in collecting cannabis-related taxes from licensees. Our inspection and audit division, health and safety, also performs audits and inspections of cannabis facilities. They track and monitor all inventory from seed to sale and audit monthly and quarterly reports from licensees that are required by us. And they evaluate all complaints made against the licensed facility, including incident reports. Our investigations and enforcement division reviews and processes transfers of interest for change of ownership requests. They vet potential licenses and affiliated owners, officers, and board members, which includes a full suite of background checks and financial analyses as part of a required suitability review. They also partner with local and state law enforcement regarding criminal investigations into enforcement on illicit market activity. What types of licenses do we hold? Currently, we have 6 different types of licenses: cultivations, the growers, producers, those that make the products, retail and dispensary, which is probably what you're most familiar with. That's the point of sale. So they actually can sell to consumers. Cultivation and production sell to other cannabis establishments. We have testing labs that test all the product to ensure the health and safety of the products that go out to the consumers. We have distribution licenses, and they're able to transport cannabis from one establishment to another. And lastly, the newest type of license is the consumption lounge license, and they're licensed to operate businesses for the consumption of single-use or ready-to-consume cannabis products on site. Taxable sales. So I know that this has been a question that everyone's had regarding how much revenue we bring into the state. As you can see in the gray line, taxable sales reported by adult use retail stores and medical dispensaries in fiscal year 24 was $829,225,193. That is a decrease of 2% compared to fiscal year 2023. Also, please note, $43.7 million was collected for the 15% excise tax in fiscal year 2024, which funds us, and I'll kind of elaborate on that more in the next slide. And $76.8 million was collected for the 10% state retail tax in fiscal year 2024. As with any industry, the market will dictate demand. My goal in these areas is to provide certainty, fair playing field for industry, so they know what's expected of them, and to provide stability to withstand these types of economic downturns in sales. Distribution to state education fund, which again I know is always a hot topic. So the distribution to the state education fund in fiscal year 2020 or fiscal year 24 was $107.8 million. As mentioned, the retail cannabis excise tax at point of sale was 76.8, and then the wholesale cannabis excise tax, that was 31.2. Just a quick overview of that. NRS 372A directs all revenue from the 10% state retail cannabis excise tax into the state education fund, which some of you formerly may know as the distributive school account. The state wholesale cannabis excise tax revenue collected is transferred to us, the CCB, and used to support the agency's operations and the regulatory oversight of the cannabis industry in Nevada. CCB also distributes a total of $5 million of that revenue collected from wholesale tax to local governments to carry out the provisions of NRS 678C and D, and the remaining proceeds are transferred to the State Education Fund by the CCB, along with residuals from civil penalties, licensing, and fees collected as outlined in statute. Nevada Department of Education is actually then responsible for the distribution from the State Education Fund to the school districts themselves. Industry snapshot. So currently we have 387 total medical and adult use operational licenses statewide. As you would probably imagine, the highest concentration of operational licenses is in Southern Nevada, 260, which include Clark, unincorporated Clark, Las Vegas, North Las Vegas, Henderson, and Mesquite. We then, secondly, 62 operational licenses in Washoe County, unincorporated Washoe, Reno, Sparks. Breakdown of our license types, the 6 that I mentioned before. We have 128 cultivation types, or 128 cultivation, 100 production, 8 independent testing labs, 103 medical dispensaries / retail cannabis stores, 46 distribution facilities, and 2 consumption lounges. Industry snapshot, keep going on this one. Cost of an agent card is $150 per category, and each card is valid for 2 years. Each category requires a separate card at $150 each. So again, those 6 license types. So if you worked in a cultivation and production, you would actually need both cards. CCB receives an average of 1,012 agent card applications monthly, and then we issue subsequently 902 temporary agent cards, which we're very proud of because we can get those turned around within about 48 hours, which again, we're very proud of because it enables people to either continue to work or start working in the industry. And then active agent registration cards, 20,397. Laws and regulations, if you want to do a deep dive on us, we also have all our rules and regulations that govern the CCB. They can be found on the CCB's website under the Laws and Regulations tab. This page includes Title 56 NRS 678A through D, as well as the Nevada Cannabis Compliance Regulations. Please note, though, that our NCCRs are soon to be NACs, but currently they're broken down by regulation. Current trends and challenges. So as mentioned before, tax revenue and sales revenue in 2024 was down compared to FY23 and FY22. We have found this decline to be consistent with sales trends in other states with more mature cannabis markets like ours, and can be attributed in part to after effects of the COVID-19 pandemic. Other challenges: unregulated cultivation, production, and sale of cannabis, also known as the illicit market. And nationwide concerns regarding synthetic cannabis. We released a cannabis market study that was contracted by us that estimates the illicit market size at $242 million, or about 21% of the total cannabis market in Nevada. So that kind of speaks towards the size of the illicit market. You may have also heard of intoxicating hemp or synthetics or Delta-8 THC. National concern is growing over these products, which are often sold in smoke shops and gas stations. We do not currently regulate those, but there is some concern over those products that are over the allowable limit to be considered hemp, and those would be the intoxicating hemp. Over my time here, agency operations and efficiencies. White Pine County licensing, we issued 1 cultivation and 1 production license late in 2024. Very proud of that. That was the 2nd licensing round in agency history for those 2 types of licenses. Cannabis consumption lounges opened as well. They're expected to open on a rolling basis, and currently we have 2 cannabis consumption lounges open. CCB also purchased a mobile lab. In 2024, the CCB enlisted the mobile lab to test edibles, plants, concentrates, and infused products in the field. The results take about 15 minutes. It's an incredibly terrific product, and we've been able to use it to assist law enforcement across the state already. And additionally, I just mentioned the market study, which was commissioned as an independent market study as required by NRS 678A. Agency operations and efficiencies. So based on the governor's initiative, we've really championed economic growth, creating a business-friendly regulatory environment. Public safety, I mentioned the illicit market before. We've been partnering with DPS and other law enforcement agencies out around the state on the illicit market concerns. Government support services, recruiting and retention of a talented team. I think we have the best team in the state. Providing outstanding customer service to our licensees and collaborating with other state agencies like tax, DPS, and the Department of Ag, among other. Office organizations, the new supervisory positions that were approved by the legislature in 2023 in the audit, inspection, and investigations divisions have improved efficiencies within their division. Staff training and improvement in the interim CCB team received numerous trainings and utilized resources inside and outside the agency, leveraged trainings from other state agencies, and provided numerous trainings to licensees and industry stakeholders. Recruiting and retention, CCB I think is a pretty desirable place to work. We've created an innovative, forward-looking agency, and we currently have a vacancy rate of 1%, which we're pretty proud of. Audit and inspection teams completed all field work, again, happy to announce, and 100% of all licensees were visited in 2024. Regulatory updates, the board, as dictated by the governor's executive order, considered multiple regulation changes which were workshopped and approved in June of 2024. Bill implementations that were passed during 2023, the 2023 legislative session. SB 195 dealt with disciplinary action, which revamped the provisions relating to disciplinary action taken by the board, including the settlement process for any complaints. It also limited civil penalties to a max of $20,000 for any single violation. Fees and costs, it eliminated time and effort billing for audit and inspection. SB 328, among other things, moved us into the APA. CCB is no longer exempt from the Administrative Procedures Act. LCB is currently revising the NCCRs into the NAC format, as I noted prior, as well as the regulatory changes that we submitted in June of 2024. It handled the board composition, the terms of office, the qualifications, and the training of board members, and the executive director appointment. The CCB also welcomed 2 new board members, one in January 2024, and another member that starts, that his first meeting will be in this February on the 20th, and proud to say that based on statute, he underwent his initial training this week. SB 277, this was another large bill from the 23 session. As noted earlier in the CAC subcommittee, the rescheduling and descheduling subcommittee actually handled this part. It required the CAC to provide a study and recommendations concerning the potential effects of the Nevada cannabis industry if cannabis were to be removed from Schedule 1 of the Uniform Controlled Substances Act or the Federal Controlled Substances Act. We submitted that report on February 29th. Dual licensing, CCB combined licenses for both medical and adult use, creating one fee for license renewal. Subsequently, all licenses have been combined. Individual sale amount increases, we sent out a notice to industry as adjustments were made to the tracking and inventory systems as it increased the individual sales amounts. Excluded felonies, this required the board to develop and implement a process by which a person who has been convicted of an excluded felony offense may submit to the board a petition for an exemption from those prohibitions. 9 have been submitted in total, 4 were approved without conditions, 3 were approved with conditions, 1 did not respond after their hearing, and 1 has not brought the requested documentation to the board, so it is working. Those folks that we've been working with have been able to enter the industry. Issuance and renewal fees, it decreases the maximum amount of the fees the CCB is authorized to charge for the issuance of renewal of an adult use cannabis license. And secure entrances authorizes any cannabis establishment to have more than one entrance, so long as each entrance is secure. Lastly, legislative initiatives for the 83rd legislative session. We have AB 76, which I believe the chair's been kind enough to hear next week. So we will be back in front of you. Amend statutory language to dovetail with the requirements of the APA, clarifies the requirements of ID scanning in cannabis sales facilities, definition of synthetic cannabinoid, adds language to allow for immediate temporary cease of operations due to imminent health hazards, consistent with other agencies that oversee public health, revises package size limits to be consistent with new possession limits and industry standards, and a few other conforming changes. Additionally, I think there will be a pretty substantive amendment that we will bring forward. We've heard from industry, and so we've been working closely with industry and key stakeholders, and actually spoke with another one yesterday. So we'll bring some substantive changes to that, so we'll submit that to the committee prior to our bill hearing. And with that, Chair, I think I kept in time. We are available for questions.
Thank you for that. You were like right on
I was right on the cusp, right?
But with that, members, jump in if you have any questions. Right now, I don't see any members requesting any questions, but I'll give it a moment, so.
You're going to see us
I'll
next
give
week?
it a moment, yes.
See us next week?
Yes, I'm waiting to see him online. Okay, we'll start. Our first question will be from Assembly Member Ornlicker.
Thank you, Chair. Thank you for your presentation, and you showed us the decline in sales and revenues, and you mentioned you attributed it to the after effects of the COVID pandemic. If you could elaborate, are you saying that people were home and smoking more, and now that they're back out and working, they're less interested? Is that, or is there something else going on?
Chair, do you mind if I go direct? Thank you. James Hum, for the record. Yes, Assembly Member. We can attribute it to that as well. And as I noted, it's a more mature market now, right? So I believe it's 24 states that have done adult use recreational nationwide, as well as I believe it's 38 that are medical. So, we are one of a larger market now as well. So yes, but it can be attributed to that. People were out more, consuming more, but also as well, other states still have the product as well.
Assembly Member Hanson.
Thank you, Chair. Thank you for being here and for the good presentation. I had a question. When you mentioned the illicit market, I think you said like 21%. Can you tell us do we understand how the product is being acquired in the illicit market, and then how is it being sold? Where is the problem?
Yes, thank you for the question, Assembly Member James Hum, for the record. Numerous different avenues. Again, we've partnered with DPS to some degree, and again, we're gonna ask this session for DPS to actually take a much larger role in the illicit market. But it's numerous areas. Online. There's online sellers. That have also illegal delivery as well. Some of this illicit market products, just finding different avenues to kind of get into the hands of consumers. Multiple different areas. I guess it's kind of more traditional, the same ways that it's always been. But with the internet, it's much easier to find these. I must credit our Chief of Investigations, Chief Staley. So for some of these things, some of these intoxicating products that are over the legal limit, we're issuing cease and desist orders because that's under our purview to try to keep that stuff out of that product out of our market, just to really make sure that that doesn't enter the market. And that's more of the online and mail sales, but more of on the illicit market side, state and local law enforcement entities currently have oversight over that, and that's why we're working with DPS to further that. So they'll be bringing a budget request for additional staff to tackle the illicit market. Thank you.
Thank you. We will return to Assembly Member Ornlicker.
Thank you, Chair. And this question I have is about consumption lounges. You mentioned 2 have opened, and I was wondering if that's what you expected when we passed the legislation. I know at the time there were concerns about consumption lounges based on other state experiences, that they didn't play out as fulfill the potential that was expected, and we thought we were learning from the experiences in other states. So is it just, it really takes time, or are we not seeing it as much interest as we thought there might be?
Thank you for the question, Assemblymember James Hum, for the record. I think it's, I would say yes, that's an accurate assessment. It really just depends on demand. So I was not here when consumption lounges were approved. But as we've kind of looked at it, talked to the market, I think, again, anecdotally, we don't have enough data yet since there are only 2 open. But anecdotally, I believe that the 2 that I've spoken to, the 2 that are open, have been successful. But again, as with any other industry, I believe that demand will dictate the market. We have 38 additional available to be opened. So I think, honestly, time will tell if there really is demand for those consumption lounges. But again, anecdotally, we don't have any hard evidence. In some cases, I think one's been open 6 months and one 8 months. So we'll continue to study that and look at that and see if demand arises. I certainly think that, Nevada as a market would have some demand for that, given our tourism and entertainment industries that we have here. So I would certainly say it's something we'll keep an eye on.
Thank you for that. And we don't have any additional questions. So with that, and I appreciate you brought a whole team prepared for questions too, but your presentation was very concise and informative. So thank you for that. I will go ahead and close this agenda item and open up our next item, which will be a presentation from the offices of the district attorney. So next we have Mr. John Jones, Chief Deputy District Attorney from Clark County. And we also have Ms. Jennifer Noble, who is the Chief Deputy District Attorney from Washoe County. And so with that, I'll give you both a few moments to get ready, and then just please proceed when you're ready.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, and I'm here on behalf of the Clark County District Attorney's Office. I have been a Chief Deputy District Attorney in the Clark County DA's office now for almost 20 years. With me, as the chair indicated, is Jennifer Noble. She is a Chief Deputy District Attorney in the Washoe County District Attorney's Office and has been there around 17 years. Together, the 2 of us represent the Nevada District Attorneys Association. That association is made up of the elected district attorneys in the state of Nevada. It's been an honor for me since the 2011 session to represent the Nevada District Attorneys Association. So this is my 8th session, and this is Jennifer's 5th session. So we have been around the block quite a bit in this legislative building. The question we get most often from people is, what in the world does a district attorney do? A lot of times people approach our job with what they see on television. And oftentimes on television, the DA is portrayed as the antagonist, the one who's most concerned about the win at all costs attitude, evidence be damned, innocence be damned. But that is not at all what our job is like, what our ethical and legal responsibilities are. We represent the people of the state of Nevada. We do not represent law enforcement. We do not represent an individual. We represent the people. We handle all kinds of things. Now, Jenny and I focus mainly on the criminal aspect of the DA's job. We handle misdemeanors that occur in a county, excluding those that are found in an incorporated city. The city attorneys handle those misdemeanors. We also handle all gross misdemeanor and felony cases. We handle juvenile cases, child support, child welfare, victim and witness support, and we also represent boards and agencies of our various counties. I will say we do not, Jenny and I's day job is not a civil attorney, so we don't belong to our civil divisions. If you have questions about what our civil divisions do, at least from Clark County, we have Jeff Rogan, who is here. He represents Clark County, but he is a member of the Clark County DA Civil Division, and he can help answer your questions about any civil division. But the rest of the divisions, Jenny and I are happy to speak to you individually about what our offices do. We're also happy to set up office visits. If you would like to come visit with the DA, see what we do in court when we're not here at the legislative session, please contact us. We are happy to set that up in any jurisdiction in this state. So let us know, and we'll make that happen. As Chair Miller indicated yesterday, she went on a ride-along with law enforcement. It's probably not going to be as exciting as that, but it still gives you an interesting perspective about what we do. Again, as I mentioned, there are 17 elected district attorneys in the state of Nevada, one for each county. And our office sizes range from one attorney, the elected district attorney, to Clark County's office, which is approaching 175 attorneys. We're one of the larger prosecuting agencies in the country. And we're broken down into various divisions, as I've also articulated. And you can see here on the slide that we have various specialty teams as well: homicide, SVU, gun crimes. If you have any questions about these, due to some time constraints today, I'm not going to get into them, but feel free to ask. I'm happy to tell you what any of these specialized units do.
Good morning, Chair Miller and members of the committee. Jennifer Noble on behalf of the Washoe County District Attorney's Office. Here you see the structure of our office. It's a bit smaller, as you might imagine. Our criminal division has 3 felony teams, all of which handle a wide range of felonies, from drug trafficking to sexual assault. Our intake team appears at pretrial release hearings and handles initial charging of felony cases. Our major violators unit generally handles our most egregious or aggravated cases, including sexual assaults and homicides. We also have a misdemeanor team and a team of prosecutors who handle juvenile cases. We also have an appellate team, and that's what I oversee. We handle all appeals from felony convictions. Additionally, we have a civil division, family support division, and child welfare division. And our child advocacy center prosecutors serve the youngest victims in our community. We also have a victim witness assistance center, investigations team, and a conviction integrity committee. Now, in prosecuting cases in both the Clark County and Washoe County District Attorney's Office, as well as throughout the states, prosecutors focus on the 3 Ps: protecting victims, prosecuting cases, and promoting justice. We have victim witness assistance centers in both offices to offer support and information to victims navigating the criminal justice system, often one of the most difficult times of their lives. We work with community partners to connect victims with other services that they might need, and we also work to ensure that the victims' constitutional rights under the Nevada Constitution are honored by keeping them informed of hearings and supporting their participation. And this obligation not only falls on prosecutors, but on the entire criminal justice system. Our victim advocates accompany victims to court, and they notify them about scheduled hearings. They provide explanations about what's going on in the case and facilitate meetings with the assigned prosecutor. They also provide emotional support, identify needs, and again, help connect victims with wraparound services. Some of the community partners that we work with include Victims of Crime, Safe Nest, Safe Embrace, Rape Crisis Center, Legal Aid Centers, the Children's Cabinet, and the Housing Authority. And I won't go too into this because I know we're trying to keep our presentation shorter than last year. It's the same, okay. The Washoe County Child Advocacy Center is accredited by the National Children's Alliance. It's a multidisciplinary team of prosecutors, therapists, investigators who provide wraparound services to children who have been sexually abused, physically abused, or suffering from serious neglect. The multidisciplinary team again includes physicians, nurses, mental health providers, law enforcement, prosecutors, and specially trained forensic interviewers. It uses an evidence-based approach to promote best practices and minimize further trauma to the child, and maximize support and resources to the child and their family. We're very proud of the Washoe County Child Advocacy Center. We invite you to come take a tour, speak to the prosecutors and members of the multidisciplinary team at any time. I'm happy to set that up for any one of you.
And John Jones on behalf of the Nevada District Attorneys Association and the Clark County District Attorney's Office. And we did get 15 to 20 minutes last year, but we were at the dais almost an hour. So we're trying not to take an hour of your time today. So prosecuting cases, the second of the 3 Ps of our criminal division. And this deals with making a charging decision, bail arguments, preliminary hearings, trial, and ultimately sentencing. Our power to hold people accountable for their crimes is carefully defined by the law and our ethical responsibilities. And throughout that process, there are checks and balances on us and layers of accountability, be it judges, be it defense attorneys, talking to victims, talking to law enforcement. The most important, arguably the most important decision a DA makes is whether or not to file charges. Whether or not to basically point the finger at somebody and say, you have done wrong. And when officers book a defendant, they are giving us a suggestion of what charges they believe the defendant has engaged in. This is what we think the defendant has done. Our offices then make an independent decision about whether or not we can prove that case beyond a reasonable doubt. So if an officer says, I believe that somebody has committed the crime of home invasion, a DA will look at the elements of home invasion. They will look at the evidence that the officer has offered and make a decision about whether or not we can prove that case beyond a reasonable doubt. That is my ethical obligation. Do I think I can ultimately prove this case beyond a reasonable doubt? And if I can't, I am ethically obligated to deny that case. And I give this example because these are two crimes that are pretty closely related, but different. So the elements of home invasion are entering a home of another using force of some sort. Residential burglary is unlawfully entering the home of another with a felonious intent or an intent to commit assault or battery. So sometimes officers will submit on a residential burglary and a DA will be, nope, I'm not going to prove residential burglary, I'm going to prove home invasion. Or sometimes we'll deny the case altogether. But I make that decision independent of what a law enforcement has submitted to me. If I believe that the defendant is guilty or that I can at least prove it beyond a reasonable doubt, I then file a criminal complaint, which you see here. And it's a document filed by me that notifies the defendant of what charges I'm filing against them and a brief little statement about what I believe they have done. So in this instance, it's home invasion of the home, and it gives the date, the address, and the name of the person that they've committed the crime against. And around the same time that I'm making that charging decision, we're also preparing for what we call bail hearings. So if a defendant has not bailed out of jail within 12 to 24 hours, but no more than 48 hours, we're required to have a Valdez hearing. And that is a prompt, individualized hearing in which I have to prove by clear and convincing evidence that there are no less restrictive measures to ask for bail. And typically what we look at is their prior record, the nature of the offense. Have they failed to appear? Do they have stability factors? A family, a residence, a phone? Those are all statutorily required for us to look at. And ultimately, it is the judge who sets a bail. So if a judge feels that I have met my burden, then a judge can set a bail in that instance. But they can also set other release conditions. They can put somebody on what we call electronic monitoring, which is an ankle bracelet, which monitors their movements. They can restrict locations that the defendant can go to. They can say, you are not to consume alcohol while this case is pending, if the criminal conduct appears to be alcohol related. Those are all permissible for judges to do. I'm going the wrong way. And then most cases in Nevada negotiate. When we file charges, well into the 90% of cases negotiate. Our system is built on negotiation. We cannot take every case to trial. There are not enough judges, there are not enough courtrooms, there are not enough defense attorneys. We have to negotiate cases. And there are many factors that go into negotiation of a case. Cases that seemingly are similar often are not. So the defendant's history is important. The strength of the witnesses or evidence involved in this particular case is important. The seriousness. And again, my ability to prove it beyond a reasonable doubt. Are there issues? Do I think maybe this witness isn't going to perform very well on the stand? That is all relevant in a decision whether or not to negotiate.
In preparing for trial, prosecutors review the evidence submitted by law enforcement. We evaluate the quality of that evidence, and we also may ask law enforcement to conduct additional investigation into an aspect of the case. In a criminal trial, prosecutors have a unique obligation not only to provide to the defense all of the materials that we plan to use at trial, but also to provide materials that might be exculpatory. In other words, explaining away the charge or impeachment evidence. For example, something that might call into question a witness's testimony. Both the state and the defense have the ability to contact witnesses, subpoena witnesses, and file motions regarding the admissibility of certain evidence in a case. Moving to trial, the defendant, of course, has a right to trial before a jury of their peers, 12 jurors for felony cases and 6 in some misdemeanor cases. They make factual determinations, including guilt or innocence of a defendant, and every element of the crime must be proven beyond a reasonable doubt. The decision of the jury must be unanimous, and the defendant has no obligation to present evidence, testify whatsoever. And we are not allowed as prosecutors to comment upon that in front of the jury, and the jurors are actually instructed that they cannot hold that against a defendant. Now, what exactly is reasonable doubt? In Nevada, we have a statutory definition, and it includes instruction or guidance that a reasonable doubt is a doubt based on reason, not mere possible doubt, but such that would govern or control a person in the more weighty affairs of life. Jurors to convict must feel an abiding conviction of the truth of the charge, and doubt to be reasonable must be actual, not based on mere possibility or speculation. This is a burden that we welcome, and if we don't meet it, the jury must do the right thing and acquit the defendant. Sentencing usually happens between 2 and 6 months after a guilty plea or jury verdict. The Division of Parole and Probation provides a report with background information regarding a defendant's social history, their criminal history, and often their medical history. Both the prosecutor and the defense attorney argue for a sentence within the range prescribed by statute, or if it's a guilty plea guilty plea agreement, within the parameters of that guilty plea agreement. Ultimately, it is up to the judge to exercise their discretion and impose a sentence as long as it's within the statutory framework. Post-conviction proceedings. This is what I deal with on a day-to-day basis. After conviction or trial by plea, after conviction by trial or plea, the legal process continues for many years, and this is something that you really don't see on TV. And a lot of victims are surprised to learn about how long this process often takes. But defendants may file a direct appeal with the Nevada appellate courts and or a petition for writ of habeas corpus with the district court. That often challenges basically the job that they feel was done by their trial counsel. Defendants can also file a motion for new trial, a petition for DNA testing, a motion to withdraw their guilty plea, or a petition to establish factual innocence. And I note with regard to requesting DNA testing and petitions to establish factual innocence, those can be filed at any time after the conviction. There is no time limit in terms of when a defendant or convicted person can file those.
John Jones on behalf of the Nevada District Attorneys Association. The third P is promoting justice. And our little quote on here, our success is not measured by the number of convictions. It's whether or not we're working for fair and just outcomes for the victims and the community at large. And we do care about ways and focusing ways to stop the cycle of offending. We work with victims. We talk to defense attorneys to figure out what is causing the issue that this particular defendant is presenting with. Sometimes when the defendant is known to the victim will give us some information about why they think the defendant has engaged in this conduct. We see that a lot in domestic situations. If not, we're listening to our defense attorneys. Here's what I think the problem is. Here's what I think we need to do to address it. And we do take that into account. Assemblywoman Hansen always says that she cares about the balance between justice and mercy. And we absolutely do as well. Sometimes we focus a little bit more on the justice side because that is what's deserved in this case. But there are cases where mercy is deserved. And we do allow for dismissals and things like that, deferred adjudications when it's appropriate. And we talk to victims, we talk to defense attorneys, and we try to fashion a negotiation that is in the best interest of the community and justice generally. I will say, though, the old adage that when all you have is a hammer, every problem looks like a nail. We need more options for drug and mental health treatment. I'll say that again. We need more options for drug and mental health treatment. We have some great programs, which we're going to talk about here in a second, but they are not solutions for everybody. And especially if somebody has a mental health condition and they present with violent tendencies, these programs are not appropriate for them. And you'll find that we have very few resources to put people, defendants, with violent tendencies out in the community. There are very few. Same with those with substantial drug or co-occurring problems. We need more options for drug and mental health treatment.
And so I am going to ask that we just speed it up because, again, consistency is what leads to fairness. So, and you know that our schedule only gets tighter as we go. So thank you so much.
Go ahead. I skipped a slide, so go ahead.
So briefly then, I will touch upon the specialty court systems, particularly in Washoe County and Clark County. Our specialty court options have been becoming more and more robust than they were in the past. In addition to holding defendants accountable, prosecutors also want to set them up for future success. That means ensuring appropriate treatment and assistance. We have drug court services, persons struggling with addiction, provides referrals to treatment providers, housing assistance, etc. Participants are separated into different dockets based on their risk and need. We also have mental health court, which focuses on offenders who are in the criminal justice system due to a mental health condition. Wraparound services are also provided to those folks. Specialty courts also include Veterans Court, which focuses on the rehabilitation of those who have served our country, focusing on service-related conditions such as brain injuries, military sexual trauma, post-traumatic stress, anxiety, and depression. And it serves veterans from jurisdictions throughout northern Nevada. Includes drug addiction treatment, mental health, and psychiatric services. And we do collaborate with the Veterans Administration and veteran charities to connect participants with wraparound services. Both the Washoe County District Attorney and the Clark County District Attorney's Office have mechanisms in place independent of statutory obligations to review post-conviction petitions and review credible claims of factual innocence. Washoe County District Attorney has the Conviction Integrity Committee. Clark County District District Attorney's Office has a Conviction Integrity Unit. Both were set up prior to the creation in 2019 of the statutory petition for factual innocence, and essentially the same standard is applied. We also have in Nevada the Prosecution Best Practices Committee. This is a collaborative group of prosecutors, county prosecutors, city prosecutors, representatives from the Attorney General's office. The chair attends conferences regarding best practices around the country. Purpose of this committee is to have important conversations about how we as prosecutors can better serve our communities and improve our services and elevate our practice.
John Jones on behalf of the Nevada District Attorneys Association. We want to end with this quote: "A prosecutor's primary duty is not to convict, but to see that justice is done." With that, Chair Miller, we're happy to answer any questions that the committee may have.
Thank you. We do have a few questions already. We will start first with Assembly Member Ornlicker.
Thank you, Chair. One of the questions I have when we read the academic studies, we learn that the likelihood of arrest is more important than the severity of the sentence in terms of deterrence. And I know we often pass bills to increase minimum sentences, but how are we doing in terms of taking account of what the academic studies are and focusing more on likelihood of arrest rather than severity of sentence?
John Jones on behalf of the Nevada District Attorneys Association. I've seen it phrased more like the immediacy between when the event occurred and when the potential punishment occurs as more of the driving factor. But I think that's essentially what you're getting at. I agree with the sentiment of the question. The sooner that we can intervene, the better the outcomes, especially when you're talking about domestic violence cases. That's the one that pops into mind as soon as you said that. Because if an arrest isn't made initially, then we're talking sometimes months before a warrant is issued and a defendant is brought in front of a judge. And by that time, the residence has returned to some sense of normalcy. We're at the top of the cycle of abuse where it's a loving household. And of course the victim doesn't want to prosecute at that point because things are great. And so that is the best answer that I can give you is I think it is important for us to get involved sooner in some of these cases. But there are statutes, specifically some arrest statutes, that prevent law enforcement from arresting after a certain period of time, or if the offense did not occur in their presence. And in those situations, we have to get a warrant, which takes time for us to review it. It takes time for the judge to review it. It takes time for the warrant to get into the system. And then it takes time for the warrant to be served. So I agree with the sentiment of your question, which is I think we need to intervene earlier.
Thank you for that. Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you, Deputy Attorney General. So my question is regarding sex trafficking. We know that this is a big problem in Nevada. So what your office is taking the measures to control it?
Thank you for the question, Assemblymember. Jennifer Noble for the record. In my office, we have a prosecutor that is dedicated specifically to sex trafficking cases that works closely with law enforcement and operations to identify folks who may particularly be seeking underage individuals for sex, unlawful sex. And we have had great success with those programs, a number of arrests, a number of felony convictions. So while sex trafficking isn't only handled by that prosecutor, she does try to focus on best practices, collaboration with law enforcement, and seeing if we can identify those individuals who are interested in sex trafficking, the buyers in particular, and get them into the criminal justice system.
And we see the number decreasing?
Jennifer Noble for the record. I don't want to represent something to you. I don't have the numbers in front of me. I can tell you that the number of arrests for sex trafficking are increasing in Washoe County, but I could get you the precise numbers if you'd like.
Thank you so much.
Just out of curiosity, does Clark function the same way?
John Jones on behalf of the Clark County DA's office. Yes, Chair Miller, we do. We have 2 specialty prosecutors that handle them, and we also work closely with law enforcement. And I as well will look and see if I can get stats regarding sex trafficking cases in my office.
Thanks so much. Our next question is from Assemblymember Hardy.
Thank you, Chair, and it's good to see you both again. So I wanted to just touch on a little bit about like the diversion programs and then the specialty courts. So it says if they fail to complete the program or they commit another crime during that, then they're out of the diversion program and then the case proceeds. Is that they're out, or does it depend on the charge? And then going along with that, the specialty courts, do you have data that shows those that successfully complete those, you know, they don't reoffend? Do you have anything that you could share with us regarding that?
John Jones on behalf of the Nevada District Attorneys Association. Great question, and my answer is, with respect to the first part of that question, it depends. There are defendants who pick up new crimes when they're in one of these specialty courts, and we'll take a look at that crime, and then we'll make a decision. Should we seek to terminate this person from the program, or can we implement some type of sanction and continue them in the program? Ultimately, that is the judge's decision. I cannot unilaterally terminate somebody from a specialty court program. So the judge would take into account my argument, the defense attorney's argument, and then render a decision. With respect to the second part of your question, I don't have stats regarding specialty court success rates, but the courts do. In fact, I sat through a presentation yesterday in Senate Judiciary of the Administrative Office of the Courts, and they talked about their stats that show that yes, there is reduced recidivism for defendants who have completed specialty court. And I think that's borne out nationally as well. So that's pretty uniform with what we see. They are extremely intensive programs. So we would expect to see a reduced recidivism for people who actually complete it.
Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you so much for being here. I'm happy to see you back again. So my question is around negotiations and pleas, and I really appreciated, Mr. Jones, your comments about how each case is unique, and obviously our system cannot handle every single one of these going to trial. So my question actually is directly for Ms. Noble about Washoe County. There have been several articles about a change in the plea policy in Washoe County, and for my colleagues that don't live in Washoe, I think my understanding is that the policy is now that pleas can only be for the highest charge. So we've removed some discretion and you can only plead for the highest charge or else you go to trial. And so my question is, what was the genesis of that change? And what impact has that had on caseloads, backlog, and trial outcomes?
Jennifer Noble for the record. Thank you for the question, Assembly Member. So in, I believe, mid-2023, the Washoe County District Attorney's Office did adopt policy regarding charging and plea bargaining standards, and it's important to understand that those go hand in hand. So with respect to charging, we decided to look a bit more closely at cases and make sure that we had better quality of evidence and investigation before filing. So we're guided by considerations, not just whether or not there's probable cause, but is there a reasonable prospect of conviction? And whether based on admissible and reliable evidence, we can prove the case beyond a reasonable doubt. So in plea bargaining, that stringent standard is taken into account. In other words, we have filed not, and by the way, that is not mandatory. Deputies can seek approval of their team chief and depart from that general practice. But in other words, we have a complete and detailed investigation. This person has committed a crime or a series of crimes. So with that, our baseline is to offer the highest charge on the complaint or the indictment or information. But reductions can be sought. Now, in terms of, I think there's a misperception from my perspective about how that's impacted case logs, cases and backlogs. So for example, out of 3,000 felony case filings last year, just under 0.027% went to trial. That's about 86 cases. In 2024, the criminal division of our office received 11,951 cases. Again, 31,000 approximately involved felony charges. Our total case submissions were up 14.5% from 2023, when 10,207 cases were submitted for prosecution. The top 3 felony offense types that proceeded to trial in 2024 were crimes against children, domestic violence, and burglary, robbery, and home invasion. 35% of the cases tried in 2024 were initially charged during or before the COVID-19 pandemic, which reflects continuation of backlog that is attributable in part to the pandemic. In 2023, that figure was 79%. A total of 86 cases again proceeded to trial out of a large number of cases. In 2023, that figure was 87. The combined trial conviction rate in 2023 and 2024 was 85%. And a plea negotiation was offered by a prosecutor and rejected prior to trial in 91% of trials conducted in 2024 and 87% of trials conducted in 2023. Obviously, there are a lot of numbers and different moving parts to this, but I would invite you, number one, to check out the Washoe County District Attorney website. We do have the charging standards and the plea bargaining standards on there, and I'm also happy to discuss this further offline and answer any questions you might have.
Thank you for that. Just out of curiosity, how many counties, maybe nationally or states, are following a similar system?
Thank you for the question, Chair Miller. I don't know the answer to that off the top of my head, but I'll look into that and see if I can get you an answer.
Okay, it's obviously something Washoe didn't just create. It's kind of a best practices that was adopted from somewhere.
Yes.
Okay.
Yes, thank you.
Thank you for that. Our next question will be from Assembly Member Urick.
Thank you, Chair. Mr. Jones, Ms. Noble, it's great to see you back in the building. I look forward to another session of working together to keep our community safe. I just have a real quick question, and it's something I'm just kind of hoping that you might be able to clarify on the record for some of my colleagues that I know have come to me and expressed some concern. And it relates to, Mr. Jones, part of your presentation when you had indicated what law enforcement submits to you at the time of arrest is a suggested list of potential charges. And ultimately, you have to do your own independent analysis. And I know that some of my colleagues sometimes think that the discrepancy between what law enforcement might suggest and what you ultimately bring as charges might be a symptom of over-aggressive policing or overcharging or something like that, right? And I can see you shaking your head no, and I think we're in agreement, and I think it relates, and I'm hoping you might be able to help us establish here on the record, is it potentially the burden of proof difference that is required for law enforcement, i.e. they have to establish merely probable cause, where you, under your ethical obligations, as you've indicated, have to bring charges understanding that you believe that you will be able to prove this case beyond a reasonable doubt. So can you just kind of clarify that for us so that we can perhaps address that misconception?
Thank you. John Jones on behalf of the Nevada District Attorneys Association. That is a great question. And yes, it is a function of our differing roles in the criminal justice system. In fact, you talked about the charging decisions earlier. I want to start there. My office in the 2000 and teens, we used to file about 80% of what law enforcement submitted to us, which we looked at what other prosecuting agencies were doing nationwide, and we realized we were way too high. So we reevaluated how we were assessing cases, and we tried to get to the national average, which is between 60 and 70%. Again, that does not mean that law enforcement is inappropriately submitting cases to us. My burden as a prosecutor is beyond a reasonable doubt. There is no higher standard in the law than beyond a reasonable doubt. An officer on the street works at probable cause, which is slight, even marginal evidence that a crime was committed and that the defendant committed it. That is a vastly different burden. And so it is oftentimes an officer will submit a case, and I realize there is no way I can prove this beyond a reasonable doubt. That does not mean the arrest was inappropriate. It was. A judge would find probable cause on it, but I can't prove it. There's another scenario in which I would deny a case that is not talked about a lot, and it's solved by arrest. One of our ethical obligations is, as a prosecutor, is to charge when charging is appropriate. And the courts have said to us that solved by arrest is a legitimate prosecutorial denial. In other words, there's nothing more that the criminal justice system is going to do in this case. The problem was solved by arrest. So the courts and our ethics don't want us just prosecuting people to prosecute people. So even though the officer appropriately arrested and I denied it as solved by arrest, again, that is a natural function of our criminal justice system. I hope that answered your question. Perfect, thank you. And again, I'm happy to discuss this issue more, Jenny and I both. If you have any questions, let us know and we'll come see you.
Thank you for that. Our next question will be from Assemblymember Hanson.
Thank you, Chair. Thank you for being here. Always appreciate your presentations. So first of all, I've mentioned before, I love being on Judiciary. I come here, the daughter of a DA in a rural county, but I also have tremendous respect for how our system is built. This tension between, I always say I kind of have leanings toward public defense, but I understand the importance that the DAs play in these cases. And so I almost kind of nerd out on how incredible our system is. It's not perfect. It's this tension between the state and the prosecution and the rights of the accused, which are huge. And in history of common law, the idea that we even we're innocent before, innocent before guilty, that didn't exist. And our nation is built on that premise. So I think for all of us in the room, that is the ultimate foundation of our law and an important one. And I don't mean to make a speech, but as members of this Judiciary Committee, I think we are so privileged to be able to be a part of a system that has this tension, and I respect both sides, and it needs to happen. Now, when it comes to DAs, when it comes to sheriffs, we have their voted positions, which again is another anomaly that is unique to America, that we get to elect these DAs and sheriffs as a check on that power. And so now I'm going to turn it and say, who's the check on the DAs? For instance, we have a DA maybe that's not enforcing statute, Nevada revised statute in another county per se. What is the check for the DAs in our state?
John Jones on behalf of the Nevada District Attorneys Association, quite simply the voters of the state of Nevada. That's how we've built our system. The same people that voted you into office vote in the district attorneys. And so if they feel that the district attorney is being deficient, then they have the right, if not the obligation, to vote them out of office. But our bosses are directly elected by the people. And if I may take a brief moment to address the first part of your question. I hope it doesn't surprise you to hear us say that we also want good defense attorneys on cases. There is nothing worse for a prosecutor than to have to be both the prosecutor and the defense attorney on a case. Because I care about the validity of my conviction. And if I have a bumbling or stumbling defense attorney on the other side, my conviction is built on quicksand. I care about that. So to your point, and I know you say it all the time, Assemblywoman Hanson, and I appreciate the defense side too. They're essential. So I get that. And nobody wants a good defense attorney on the other side more than a prosecutor.
Chair, just a quick follow-up.
Quick.
Yes. Yeah, not a statement this time. So yes, the vote of the people is the check, but when there might just be some malfeasance, or maybe they've not done, and I'm even talking about underlings, not necessarily the one who's the elected. What is the check on the DA's office in general? Like if there's some sort of reprimand that has to occur, that something hasn't been done right, who is the check on your offices?
John Jones, on behalf of the Nevada District Attorneys Association, there are several checks, I would argue. One is the Nevada Bar. Just like every other attorneys, I am licensed by the state bar. If I am found to be ineffective or violate a statute or my ethical obligations, I can face sanctions by the Nevada Bar. I can also face internal sanctions if I'm found to have engaged in inappropriate behavior. And I will say there are statutory provisions that allow the Attorney General's office to provide some oversight as well of of district attorneys' offices. So there is also that check too. So there are various checks, internal and external to our offices, that keep us in line. And I would also point out judges and defense attorneys as well. If I'm engaged in unethical behavior, no one is screaming louder than the defense attorney. And then ultimately the judge is going to make a decision.
Thank you. We will go back to Assemblymember Ornlicker.
Thank you, Chair. My question has to do, I want to go back to plea negotiations, and looking at your slide, one of the factors you say that go into negotiations is ability to prove the case beyond a reasonable doubt. And I suppose that could be interpreted in different ways, but one way that's suggested by that is that if you have doubts about reasonable doubt, you will plea rather than go to trial. But if you have doubts about reasonable doubt, then shouldn't you drop the prosecution?
John Jones on behalf of the Nevada District Attorneys Association. That's a great question, because my obligation is to think from the onset of the case that I can prove it beyond a reasonable doubt. But we all know that there are various factors that go into this, especially as we begin to prepare for trial and we start to talk to witnesses. Some witnesses, they do not want to testify. They just don't. And they tell us, if I'm in front of this, if I'm on that stand, I might not do very well. I'm afraid to see the defendant in court. I'll freeze up. So I, as a prosecutor, think, is it worth putting this victim on the stand, or is it better to plea the case? Those are things that we think about as prosecutors. And so I could have child victims are another great example. And I hate to say this, but you never know how a child is going to perform on the stand. It is a situation for a child that they have never experienced before. And so I have to weigh that. Pre-trialing them, talking to their parents, is this an experience this child can handle? How do we think they'll do? So me pleading that case doesn't mean I don't believe that what the child says happened to them didn't happen to them. No, it means I'm worried that if they take the stand, it might not go very well, because I'm putting a 6, 7, 8-year-old in front of all of these strangers. They're going to be questioned by me. They're going to be questioned by the defense attorney. How are they going to handle this? So it doesn't mean I don't believe it didn't happen. It doesn't mean ultimately I didn't prove it, but there's that variable there. I hope that answers your question.
Thank you for that. And seeing no other questions, I appreciate your time, your presentation, and of course your response to questions from the members. Thank you for that. I will go ahead and close this agenda item. Last on our list for today is public comment. Again, as a reminder, we ask that anyone making public comment limit their comments to 2 minutes each. And if you have additional comments after that, we welcome you to email or submit it in writing to us. Those wishing to make comment over the phone number is 1-888-475-4499. When prompted, please enter the meeting ID, which is 824-5081-7875. And with that, we will start here in Carson City if there's anyone that would like to approach to make public comment. Also, for everyone that's going to make public comment, please remember to say your name, spell your name. I know that's probably the most difficult thing in committee, but that way we have everything accurate for the minute. So when you're ready, please proceed.
Greetings, Chair and the committee. My name is Jagada Chambers, Jagada-Chambers. I'm a Clark County School District father. I'll keep my comments narrow to today's presentation. In the 81st session, Assembly Bill 230 was passed, eliminating one of the pathways to send juveniles to adult court. That changed, but to me, it kind of opened up a new alarming trend with certifications. Certifications is another pathway for a juvenile to get to adult court. Similar to the Honorable Assemblywoman Hanson, the brain development alone should eliminate us getting 15, 16, and 17-year-olds into that adult court system. I know in 2023 in Clark County, there were 81 total. Over 50% were black juveniles, and that's kind of trending off the charts, to be honest. The pathway to certification now is kind of just the portal. It was a family in court yesterday that mother's child was, they were attempting to certify him in adult court because he was on probation and was in joyriding in a stolen car. So by the grace of God, the judge chose not to do it and chose other measures that are in place to handle our juveniles. So I just want to bring that to the attention for the DAs. I know in Washoe, I know personally that they were using bait bikes similar to like the bait cars, where they'll leave a bike out and trust that a youth will take it. And they have these expensive bikes, Treks and Cannondales that are over $10,000 in value to substantiate a higher charge. So again, I know that their job is very challenging, but we have to be realistic in how we are looking at how the youth are being governed. I know that there were over 7,000 arrests in 2023, over 3,500 from both Clark County School District and Las Vegas Metropolitan Police Department. So again, I know there was a lawsuit settled while how Clark County School District was handling a child.
And I'm going to ask you to wrap up your comments,
Okay,
please.
the final thing I'll say, I heard about a wellness bureau. I thought that was fabulous. I don't know what department spoke on it, but we need one of those in our over-policed communities to try to restore some healing. I'll say that much. Thank you all.
Thank you. Is there anyone else here in Carson City that would like to make comment? Is there anyone there in Las Vegas that would like to approach to make public comment? Not seeing anyone. Broadcasting, please open the phone lines.
If you would like to provide public comment, please press star 9 now to take your place in the queue.
Good morning. Sonia Brown, CONJABROWN, Advocates for the Inmates and the Innocent. I know that we have 5 newly elected public officials. Welcome. So I'm going to give you a little insight into the way the system is actually working. It's a great presentation the DA's office has put on before you, but there's some things that they are lacking to bring forward, and I'm about to tell you what that is, because I've been dealing with people who've been wrongfully convicted over the years. You're dealing with the appeals process, which is the first one, and it can actually start right there and during an oral argument in which the district attorney, without any malice or anything like that, just being honest, just actually got confused to the facts of a case. And that can start with, number one, causing a domino effect on misinformation, because if you go back 20, 30, 40 years, a lot of these justices were the same justices. So once the DA has said something, it's in their minds, even though they do not, the justices realize that information was false information. But it will affect the outcome. Post-conviction proceedings. When we're dealing with post-conviction proceedings, there could be 20, 30 grounds in a post-conviction petition, and the judge may only address 1, 2, 3, or 4, maybe none of the claims, and all those seeking resolution were never heard. So the goes get appealed to the higher court. The higher court will uphold usually the lower court's decision, and they never get addressed. And then it becomes an issue because all of those grounds very well could have been reversible. So these are some of the instances. Now I do want to touch on one other thing, because the comment was brought up about who oversees the DAs. I can tell you that the Attorney General's office oversees the DAs through a pattern or practice, a law that you implemented a few years ago. And I'll give you an example of how that works. The CIC, with Ms. Noble brought up, 2 applicants from 18
Ms.
to
Brown?
22 applied.
Ms. Brown,
Yeah.
we're over time, so I'm going to ask you to wrap up your comments, please.
Okay, I can just tell you that the CIC does not follow their policy, and then you can file with the Attorney General's office when they don't follow their policy. And I can just say that the 2 applicants, one was a Brady violation, one was without. The one without the Brady violation got a thorough review.
Okay,
and the
thank
one
you,
with
Ms.
the Brady
Brown.
violation, the applicant did not. Thank you.
Thank you. Next caller.
Chair, the public line is open and working, but there are no other callers to provide public comment at this time.
Okay, thank you for that. Well, with that concludes our agenda for the day. Thank you, members, and thank you, everyone in the audience and those who presented. With that, I will adjourn this meeting and see you right back here tomorrow at 8 a.m.